The petition raises.
Lord, one thing I would like to point to your lordship. Lord, there is a 3 judges bench order by your lordship. Where in fact, which is not produced in the petition. Lord, if your lordships kindly have a look at this.
Let's kindly.
Your lordships expressed 1 minute before you start.
Kindly.
Lord, your lordships expressed a view. Please see, Lord, the order.
Can I have a copy?
Yeah, I'm just giving it. Lord, please see page 2. Page 2. Page 2. In fact, my Lord Justice Anirudh Bose is a party to this. The present petition stands allowed in terms of prayers A, so and so. Now, please read the last line, Lord. This court expects the state of Bihar is not a party before this court in this petition. As such, we make no comment as regards notification issued by the state of Bihar, legality of which have been challenged in this report. But this court expects the state of Bihar shall take into account the judgment of this court delivered on 11th August. Now, Lord, 11th August judgment states you will not consider B.Ed candidates, only B.Ed candidates.
Yes.
Accordingly, though the exam was conducted for everybody, Lord, we have now declared in view of your lordship judgment the results for B.Ed candidates, and we have appointed over 1 lakh candidates, out of which 62,000 have already joined for primary 3. So, state of Bihar has complied, Lord, in accordance with your lordship judgment. This is in fact.
May I now address?
Yes.
Lord, before my petitioner starts, I'm not for the respondent. Lord, this matter was listed before Justice Gopana. Justice Gopana sent it here. Lord, there are several other MAs, 4 MA for clarification, which were listed, if I may pass the order, before a bench of Justice J.K. Maheshwari, and they passed the order that this be listed before the same bench, which had passed the 11th.
What are the MAs for?
MAs are for clarification. Now, what has happened is between 2018 and 2023, because your lordship set aside the notification in 2023, which is of 2018, your lordship said in the nothing about the middle. Now, in various states, various appointments of lakhs of teachers had been made, and various notifications issued, litigations also going on, processes completed, pending. So, what happens? Yes, 4-5 MAs. My lord, if I may just pass the order.
Matter pertains state of Bihar. It's confined to state of Bihar. West Bengal is not concerned with this.
It can't be piecemeal. What I'm saying is because various states have come before your lordship may have this order.
See, essentially now question is
Prospective.
whether those who are already appointed,
Yes.
they will be retained in service or they are working.
Also relates
This is not
that the process.
State of Bihar in that main issue is whether
State of Bihar
B.Ed or D.Ed candidates will be considered. That's all. Now, state of Bihar pursuant to your lordship's order of 11th August and the
my learned friend is not pointing out that despite the judgment by your lordship, the state of Bihar milits during the pendency and despite the orders allowed these appointments to continue, the process to continue.
When were they appointed?
Next, the appointment, the date of advertisement was 10th April and 30th of May of this year. Thereafter, the exam was conducted by them, allowed to be participated by us. After the judgment.
No, were they appointed after the judgment or
No,
before the
no.
judgment?
Let's,
After the judgment,
process
process But I tell your lordship,
let's kindly consider this.
Lord, the exam notification came way back in
19,000
September.
19,000
August.
persons, let's 19,000 persons had been appointed after the High Court judgment. High Court judgment was there, let's already.
My lords, the
But please see the
Rajasthan.
prayer is
Let's kindly,
Why are you?
Please see the
let's,
prayer.
I'm raising,
Let us crystallize.
That's exactly.
let's, I'm raising
At
three
present,
major aspects.
Bihar.
Let's,
I'm exactly on Bihar only, but there
Let's-
is a point here.
kindly
Lords,
let's
the
permit me.
judgment by which my lords held that it can only be D.Led and not B.Ed had struck down the NCTE notification, which was Rajasthan High Court, which was on 25th 11/2021. That's
It's
a
on the
pan-India
ground.
notification. Wait a minute. That's a pan-India notification because it was a
This is a,
institute notification. Now, once that notification was struck down, and my lords did not say that striking down, no state could have gone and acted upon it, much less Rajasthan, which was a party to this particular matter of the judgment which is
No,
pronounced.
right now we are
let's,
considering.
now,
Bihar.
Bihar.
Lord, please see the prayer. Please see the prayer. Prayer will indicate
Bihar
everything.
was a party, it had its own.
But where is the question of Rajasthan?
let's,
Who is for Rajasthan?
Bihar was the party.
Lord, please see Bihar, not prayer. Prayers in this.
let's, my petition, now let's kindly
This
see.
question is for Bihar.
Bihar, only Bihar.
Issue, because that issue came to be decided on 11th August 2023, and my lords will find in the judgment of this court, one of the writ petitions before this court was arising out of state of Bihar.
I have filed.
That is why let's the order that has been read out.
Complaint with the judgment.
Do you want?
That has been complied with today.
Yes.
Therefore, any appointment made appropriately.
That cannot be done.
Yes.
For the judgment.
Your
Will not be.
lordship have
Judgment
already
appointment can be
declared
protected
the
or not.
invalid that adjudication. Your
So
lordship.
that's
Not,
why I'm
I'll tell you,
recommending-
not the examination notice, examination.
What we are going to possibly do. Post judgment, no appointment of B.Ed.
That's right, that's right.
Pre-judgment, whether here we are concerned with post judgment.
That's right, that's right. Correct, correct. Correct.
Your lordship have already declared the advertisement invalid. You have to buy the order by your lordship.
No, 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 no.
1 minute, listen, please listen.
Post judgment, here the prayers are for declaration of result. We cannot grant that in view of our judgment.
Absolutely.
Let's kindly permit me.
For those who are already appointed, what
a
will be
different
their
matter altogether.
fate, we'll examine when.
Let's kindly-
Not the issue here. That is not the issue here.
Just the issue is in certain matters.
Or even this matter.
No, no,
he's not, he's not.
Or not then.
This is Bengal. We are dealing with Bihar now.
There
You
are
come
five
to-
states, what, on the.
We are not on that. We are right now confining our inquiry to
Bihar.
post judgment
In Bihar.
appointment.
Yes.
The prayers can't be granted for the simple reason that after this judgment, this would not survive. You-
Correct, correct.
May I now, everybody else except the petitioner has argued the case.
Okay, now you argue, yes.
Let's, the ramifications of the judgment of this honorable court, let's, are vast. The judgment has been rendered by this honorable court on the premise that the decision-making process resulting in the
See,
notification by
right
the.
now, we can't sit on appeal over.
No, let's, I'm not,
Judgment.
I'm not, I'm not,
If you ask for review,
I'm not seeking mere lordship.
these reliefs cannot.
The ground. There are aspects, let's here, legitimate expectation, is a doctrine. Let's kindly, kindly permit me to complete,
Judgment, maybe.
kindly permit me, to complete here.
Possibly in that.
Milord, one para kindly see from the same judgment, Milord. This
Already
advertisement
seen.
has gone by.
I'll show the entire judgment,
See the one side.
We are on this side or this side?
I am for the delayed candidate, this side, this side.
You are appointed, why are you worried? State is
If you are appointed,
No, Milord.
What? No, no.
Your lordship have declared the advertisement.
Why are you arguing? You are appointed.
Yeah.
The advertisement has gone, there is no chance.
I go into that issue. I am saying we are only complying with the judgment.
one minute, no, we are not saying, only the petitioner will hear, no one else.
Let's kindly see.
State of BR, yes.
The advertisement was issued.
despite the judgment of the Honorable High Court of Judicature at Rajasthan, which was in appeal before your lordships. My rules entitle me for an appointment based on that advertisement. Let me complete, minutes. Let me complete.
There is no.
Let me complete
You
this
are
submission, minutes. What I am
a
submitting.
review of this judgment.
No, I am not challenging that judgment. For the reason.
That's what you are saying.
What I am saying is, the process which started.
No, there can't be any protection.
Let's kindly consider this. My advertisement, I participated in the advertisement
Otherwise,
on the basis of the rules.
We'll dismiss the writ petition.
That's right. That's right.
Kindly permit me. Kindly permit.
Why have you come to Supreme Court?
Only two aspects. I have filed additional documents.
Not your lordship, I record my statement that we have already complied with and declared the result.
Let me complete it.
Yes.
I am not seeking your lordships to relook the judgment in the manner which amounts to sitting in appeal.
Don't see in the manner. You don't look at it at all.
Yes, in this case, I have raised a very.
1 minute.
1 minute. Let him.
Why are you arguing? Who are you for?
I am the intervener, my lord. We have 39.
We are not permitting any intervener to argue.
No intervention.
This honorable court, being the apex court, having all the powers including Article 142, which I am invoking in the peculiar facts and circumstances of the case, because right to education is a fundamental right created under Act of 2010. Simultaneously with that, so what I am saying is this,
Don't stretch it too far.
No, the vacancies, number of vacancies, a right to education, confers a fundamental right on the pupils who are deprived because of the posts not being filled up. There are more than 30,000 posts.
State is saying they fill up all the posts.
The High Court of Judicature at Patna has said, after exhausting their appointment, if still the vacancies remain unfilled, the B.Ed persons can be given a chance. I take it further, on the basis of the policy decision, right in the year 2010, when this act was enacted, the national education policy was being formulated.
All which there's no scope of arguing.
For the reason, that policy matters, your lordships, do not interfere in the policy matters.
No,
the policy specifically says, the policy
we don't.
The policy specifically says that slowly by the year 2030, DLED would be abolished. There will not be any course.
There is a judgment of this court that DLED would not.
That judgment, I am trying to impress upon your lordships that judgment does not take into consideration or does not. It does not take into consideration the aspect which deserve to be taken in this writ petition.
No.
On the ground,
You apply for review, we can examine it.
Then kindly keep it pending.
No, don't keep it pending.
Kindly keep it pending so that the review has been filed by those persons also, which is pending as of now.
We'll see when it comes.
Kindly consider this. Kindly, only 2 minutes more.
So far, you have none of them are on.
Kindly see the rules, on the basis of which
we have struck down the notification.
So these are rules, with all due respect, but the rules didn't fall for consideration. That's why I'm saying dehouse your lordship's judgment. The rules in the state of Bihar mandate this as a criteria. We were eligible under the rules.
Only one petition.
The rules have not been set aside. The rules are still in force. State today says that it will implement your lordship.
I have challenged the rules. I have challenged the rule, and
That's
part of
That's what I'm saying. Today they have
Not a judgment of this court. The judgment can't be confronted with the rules of the state. The judgment is
Anyway, let's see.
Kindly have it, all the cases on Friday, then along with those applications.
The rules say as per NCT. Once you have struck down the NCT notification.
Here will.
Plus, kindly see the rules for a minute, For a minute,
On
Page 433 minutes.
433, 434.
Page 433 minutes.
Rules are categorical.
on 11th August 2023.
Milord, before that, Milord, I want to say one thing.
No.
Trying to simulate
Let's-
their.
No, you are intervener, we are not permitting.
So let's
No, I
say,
say let
on the
it
writ
because
clause, there are no interveners.
11th August 20.
Let's kindly consider, let's
A
kindly,
coordinate bench.
let's kindly consider permitting me to, let's withdraw it with liberty to find me.
The order is.
One of us
Please
is a
don't.
party only. Of which one of us is a party had delivered
Let's,
a
may I withdraw
judgment.
it, let's. May I withdraw it, let's, liberty, so that, let's.
Want to withdraw?
But again, it will be reopened elsewhere. No, again, I tell your lordship,
It is followed.
this matter
Yes,
came up
It is
before a
falling from your lordship. I am not saying this.
Conditional withdrawal.
It is falling from your lordships itself, relates that I can seek review of that judgment which is coming.
No, that's, we are not.
Lordship.
Now the.
Your lordships. Let's, others also can file review.
If we dismiss, we are not here to advise you.
No, I am not saying that. I am not
The
saying.
way
not
we
saying that.
dismiss may.
Let's, the remedy of review millets may not be taken away. The remedy of review millets which is available to me in law millets under Article 137.
Not saying anything whether you can file it or not.
On 11th,
My lords, just
bench
one-
delivered a judgment striking down a notification.
Let's then all right millets I will withdraw simpliciter millets, well, whatever.
My lord,
remedy-
what's happening here is that under different names, there are many
The
BA.
advocate appearing for the
One
petitioner
here, then another, somebody else will file the whole.
submits.
And you won't have an offer. Your lordship may say after arguing for a while, because I'll tell your lordships why. It came up before Justice Bopanna's bench, then I pointed out this order. That is how it has been placed here.
After arguing for a while, learned counsel for the petitioner submits that his clients would not like to proceed with this writ petition. The writ petition is hence dismissed as withdrawn.
Obliged, grateful.
And application also.
Dismiss all applications.
All connected applications
Disposed of accordingly.
shall stand disposed of in view of this
I am grateful.
Obliged.
order.